indivisible, with liberty and justice for all.
Thank you, and Happy New Year to everybody. Start with roll call, please.
Wolf?
Yes.
Ewan?
Here.
Gonzalez?
Here.
Cook?
Here.
And Kibble.
Here.
Okay, review for conflict of interest. Seeing none. On the agenda, I just want to make a note that this agenda is actually a continuance of the appeal, so it is not a brand-new situation. This is a continuance. So with that, I'd accept an approval of the agenda.
I'll move to approve the agenda as presented.
I'll second.
Moved by Lindsay, second by John, to approve the agenda. All in favor?
Aye.
Aye. Okay, approval of minutes of 12:13.
I have a correction to note
Yes, sir?
on my end for the minutes. That page 4, Justin Moore was actually Justin Mortier. And I will make that change on my end for the approved minutes, but
Okay. Anything else? Okay. Accept the motion.
I'll make a motion to approve the minutes of the last meeting with the corrections by Preston.
I'll second that.
Okay. Moved by John, second by Rod to approve the minutes. All in favor?
Aye.
Opposed? Okay, thank you. All right. Because this is a continuance, we're not going to have that public comment. So we'll move on to correspondence. And I believe you received everything on your desk. Okay. All right, on to business before the Zoning Board of Appeals, which is continuance of Appeal 922 of Kevin Miller, Port Traverse Condominium Association. Preston?
got no direction at this point to provide you.
Okay, sir.
Mr. Chair.
If you would, Mr. Chairman, Peter Wendling, Township Attorney. I'm not sure, I talked to Preston earlier. I believe the board was considering some additional comment or presentation by the attorneys for each of the, by the appellant as well as the appellee. I don't know if that's up to the board whether they wish to do that. Otherwise, the board can go directly into deliberation with all of the exhibits. You do have updated findings, which I drafted. There are a couple of additional findings, actually several of them from what you had back in December. These findings provide for a variety of outcomes. You have in front of you also the possible outcomes of your deliberations in an email, which I put together for you. I matched the findings of fact to that email for each of those different outcomes. Of course, on those findings of fact, you have choices based on the outcomes, but also the planning or the ZBA has the option of adding their own findings, making revisions to the existing findings, or I think one of the parties also provided findings in the exhibits. You're welcome to use that as well, depending on which direction you go. I do ask, though, that you don't eliminate, that you use a finding in each category, okay, under each provision of the ordinance. I think what occurred before is that a lot of the findings were eliminated and everything was consolidated in a single finding and opinion of the ZBA, and that apparently is what the court didn't like and thought that that was not adequate for the record. So it is important that we utilize the findings as much as possible, even if we add some more, but not eliminate too many of them on each category of what your decision may be. But that decision is ultimately up to you.
Okay, thank you. Thank you. Yeah, what we, because of the subject matter and the importance of this, we have decided that we're going to allow for 15 minutes on each side to have a presentation to kind of refresh us on the issues before the board. And then following that, we may have a very short comment for anybody in the audience who wishes to speak. So that being the case, why don't we begin with the presentations, and we'll lead off this time with you.
Good evening, everyone. It's nice to see you again. Lauren Teichner from Olson Bisdock and Howard on behalf of the Port Traverse Condominium Association. And I apologize, I'm getting over a head cold if I sound a little bit, cough a little bit while I'm talking. We appreciate the opportunity to speak to you again tonight in support of our position that TC Water Sports does not qualify as an accessory use to the Sugar Beach Resort Hotel. And our message is not complicated, so I don't really want to talk your ears off. I know this is another lengthy presentation window, so I just want to stress 4 main points. The first is that your task is to apply the explicit provisions of the zoning ordinance. And second, we'll talk about the actual numbers of TC Water Sports customers. Third, we'll talk about TC Water Sports' comparisons of its operations to other local businesses, which we believe are inappropriate here. And fourth, we'll talk about what's at stake here with your decision. So first, your task is, in this hearing, is simple. We submit that you are tasked with applying the explicit language of the zoning ordinance. So let's turn to that language again. An accessory use is defined in Section 221, subsection 1 of the zoning ordinance as whenever an activity is conducted in conjunction with another principal use, and that activity, 1, constitutes only an incidental or insubstantial part of the total activity that takes place on a lot, or 2, is commonly associated with the principal use and integrally related to it, then that activity may be regarded as an accessory use to that principal use and may be carried on underneath the umbrella of the permit that was issued for that principal use. And the ZBA is further required to consider the requirement found in Section 221, subsection 2C of the zoning ordinance, that an accessory use shall not, and that's required language, generate any effects on neighboring properties, including but not limited to noise, parking, traffic, glare, or dust greater than or more burdensome than such impacts from the main use on the property. So under these explicit terms of the zoning ordinance, it's clear that TC Water Sports does not qualify as an accessory use to the hotel due to 2 reasons which we talked about extensively in December. 1, its standalone size, and 2, the fact that its operations directly adjacent to the property line with Port Traverse cause greater and more burdensome impacts, we believe, on Port Traverse than the Sugar Beach Hotel does when it's operating solely as a hotel. And we've talked about how these impacts include, but aren't limited to, noise from TC Water Sports' rental hut and operations on its dock, including customers shouting along the property line, and music from TC Water Sports' staff and customers, noise from the number of watercrafts docking and launching all day from early morning until sunset, right on the water's edge for Port Traverse residents to hear, odor and fire safety issues from TC Water Sports' dangerous storage, transport, and handling of fuel, resulting in multiple oil spills in Port Traverse's nearshore waters, and trespasses across Port Traverse's property by TC Water Sports' guests. And I want to clarify my point from December about trespass, the trespass impacts, because I know we had a lot of conversation about that. Port Traverse residents have never objected to customers of TC Water Sports or members of the public walking below the ordinary high water mark on the beach. However, the beach above that ordinary high water mark in front of the Port Traverse condominiums does belong to Port Traverse, as do the grassy common areas above the beach and the parking lot. And rather than walking along the shoreline, TC Water Sports customers regularly walk through the courtyard of Port Traverse and other common property, including the grassy lawn, the beach above the high water mark, and the parking lot. Port Traverse residents have watched these customers go to TC Water Sports' dock and board their rental craft after doing that. So all of these impacts, noise, fuel, and trespass, are all attached to the land, even if they come from the boat noise out on the water, to some extent. These impacts depend on the land, and we submit that you as the ZBA have the authority to regulate them. TC Water Sports is not operating a floating business out on the bay. You'll see some case law cited in our memos in your packet that say that a community on the shore of the water has regulatory authority over that connection between the land and the water. We're asking you as a ZBA to deal with what's going on in those first 50 feet off the shoreline and on the shore as well. We're asking you to regulate this area because it's principally conducted business on shore at the TC Water Sports rental sales hut. The zoning ordinance is what gives you your power to do that, and it exists to regulate these impacts and burdens of businesses on neighbors, and these are businesses on the land. So second, let's talk about the actual numbers of TC Water Sports customers. TC Water Sports, we believe, tries to downplay its impact by claiming that it likely doesn't have more than 25 customers per day on a busy day. And we believe that 25 customers at a time on a busy day. We believe that these claims are a gross understatement. TC Water Sports' own website, as you can see here in this slide, notes that it offers boats that seat anywhere from 10 to 16 people each, and jet skis that seat 1 to 2 people at a time. It also offers non-motorized watercraft, including paddle boats, kayaks, and it has historically brought in more boats from other locations as well. And we know that there were at least 10 boats and 14 jet skis in 2021 when this appeal began. These boats are rented out 5 to 6 times a day, and we believe that comes to at least 500 customers per day that come through. While it's true that these boats might not be at full capacity each time they're rented out, we think it's realistic to conclude that significantly more than 25 customers use TC Water Sports services at any given time. Even individual members of the ZBA noted during your last meeting in December that doing this math reveals that the number of hotel guests and customers on the waterfront at any time may double as the result of TC Water Sports' operations. That large number leads to these significant impacts that I've been talking to you about. These are impacts that go well beyond the impact that the hotel itself would have operating solely as a hotel. And again, these impacts go on from 8 a.m. until sunset, sometimes even 9 p.m. When TC Water Sports remains open. Even still, we submit that it's not necessarily how many customers are served per day. It's about the impact of those customers, of this number, as compared to the hotel guests, and the associated impact that the additional TC Water Sports guests would have, and that is distinct from the hotel itself. We know that hotel guests on their own, a lot of their needs would be taken care of inside the hotel. Some guests might spend time quietly on the beach. Some might go elsewhere to rent boats if TC Water Sports didn't exist there, and some may go elsewhere to do other activities if TC Water Sports wasn't there. But we think it's a really different reality with the fact that TC Water Sports is there. Their customers come and line up at the rental hut. They wait for assistance. They play music. So do the staff. And they launch and dock boats all day from early morning until sunset, again, all along the Port Traverse property line. Okay, so third, let's talk about TC Water Sports' comparison of its operations to other local businesses like Break and Waves and Blue Sky Rentals. Every accessory use determination under the zoning ordinance is fact-specific and circumstance-specific, and requires, we believe, a detailed analysis of that particular business at issue, including the size and location and impacts of that business. And therefore, whether other businesses have been approved in the past as accessory uses or not, as part of their own site plan applications, we believe is outside the scope of the evidence that you're required to consider for this case. Comparisons with other businesses have limited value because a business in one location may qualify as an accessory use, but in a different context or a different location, that same business may not qualify due to its impacts on neighboring properties. We submit even a restaurant within a hotel might qualify as an accessory use, while that same restaurant located directly adjacent to a neighboring residential property might not. But if you as a ZBA are concerned about this situation being unfair in light of TC Water Sports' arguments that other businesses have been deemed accessory uses, and with the possibility that TC Water Sports may not be, then we believe any unfairness in that context would be appropriate for the ZBA to address with township staff separately and apart from this hearing. The township can revisit those other determinations, but that's not at issue here. We submit that you should not give TC Water Sports an unfair out just because other businesses may have been wrongly deemed accessory uses in the past. This is not a question of fairness here regarding other businesses. And I would remind the ZBA that your task is to apply these zoning ordinance requirements to TC Water Sports and this particular factual situation. That is what will be evaluated by a circuit court if there's any appeal here. But even if you, the ZBA, were to look at Break and Waves and Blue Sky Rentals as a guide, we believe that both show that TC Water Sports is not an accessory use. First, as you can see on the left, Break and Waves appears to be the only building on the property located at 1469 US 31 North, and it's located in the center of that property. It's not adjacent to the property line with either of its neighbors, both of which are hotels, the Brio and Beach House. They're not residences like TC Water Sports' neighbors. And TC Water Sports itself included in its packet an email from township staff indicating that neither Break and Waves nor Blue Sky Rentals got any land use permit or site plan from the township to formalize their operations. Township staff wrote, particularly for Break and Waves, I have no idea why a land use permit was not required at that time. So we know that Break and Waves should have undergone site plan approval, but it did not. This email undercuts TC Water Sports' arguments that TC Water Sports is an accessory use, given that its own business operations are comparable in size to Break and Waves, and again, Break and Waves should have undergone site plan approval. And regarding Blue Sky Rentals, we submit that is much smaller as an operation than TC Water Sports, and you can see the tiny little Blue Sky Rentals hut next to the hotel. It is indicative of its actual accessory use here to a hotel's operations. It's not adjacent to any residential community. It does not have any ongoing and continuous burdensome impacts like TC Water Sports does on Port Traverse. Okay, so lastly, turning to what's at stake here. TC Water Sports will have the right to operate at the Sugar Beach Hotel regardless of what decision you make tonight in this hearing. And that is because TC Water Sports has already obtained site plan approval from the Planning Commission, which thoroughly reviewed TC Water Sports' operations and came up with specific requirements for TC Water Sports to follow. So they already have the authority to operate for the 2023 boating season. So if you determine that TC Water Sports is not an accessory use, this is what would happen. TC Water Sports would be limited under its site plan to 12 jet skis and one additional one for rescue purposes and 9 boats. TC Water Sports would not be permitted under its site plan approval to bring additional rental watercraft from any other locations to rent at Sugar Beach Hotel. TC Water Sports would be required to use an approved fuel trailer for storage, and TC Water Sports would be required to abide by its proffered shared parking arrangement with the hotel. If, on the other hand, you determine that TC Water Sports is an accessory use that does not generate any effects on neighboring properties greater or more burdensome than the hotel, then what would happen is that TC Water Sports would have free rein to operate how it wishes. TC Water Sports' operations would be limited solely by the terms of its Eagle and Army Corps of Engineers permits. But TC Water Sports could always apply for new permits in the future, and as part of those applications could request the ability to moor and operate additional watercraft at the Sugar Beach Hotel. TC Water Sports would be able to move the rental hut back to the property line with Port Traverse. They would be able to bring in additional watercraft from other locations to rent at Sugar Beach Hotel. They would not be required to abide by the proffered shared parking arrangement with the hotel, and they would not be required to use an approved fuel trailer. So given the significant impact on Port Traverse, which is greater than the hotel, operating solely as a hotel, we ask that you find that TC Water Sports does not qualify as an accessory use, so that it will be required to operate under the terms of its site plan approval. We also ask that you as a ZBA make detailed findings of fact about the impacts that that TC Water Sports has on Port Traverse that will withstand any further appeal to the circuit court. And just as one final note, We just want to make it clear, contrary to the assertions by TC Water Sports, the circuit court did not reverse the ZBA's initial findings or disagree with those findings. Instead, the judge simply remanded back to all of you to ask for more information to substantiate your earlier decision. It was not a reversal. So thank you for considering all of the information I've presented on the last 2 meetings. And I did also want to note for the record that I submitted some proposed edits to the meeting minutes from December 13th to the ZBA, and those should be in the record. Thank you.
Thank you. Yes, sir. Claire, are you keeping time on this?
Yes.
Thank you.
Good evening, Mr. Chairman. Good evening. Sorry. Ladies and gentlemen of the board, thank you for your time here tonight. I think this has been hashed and rehashed and rehashed a number of times, so I'm going to keep my comments short tonight. For the record, my name is Joseph Zayas. I represent TC Water Sports. In this matter, to my right is Saburi Boyer. He's the member of TC Water Sports. He's going to address a couple factual issues. And 3 things I'm going to point out very briefly for you. 2 things to keep in mind. Legal concepts of equal protection and due process. What that means in this context is equal protection means you have to treat similarly situated businesses the same. You can't single one out for requirements that aren't applied to other similarly situated businesses. And to the extent that East Bay Township does so and treats us differently, we would be entitled to legal compensation. Second concept I want to cover is due process. Due process means that a business or a person has the right to know what standards they're being held to. That means you have to hold us to the standard in the ordinance and nothing more. And there's been a lot thrown out, a lot of things that simply aren't in the ordinance. Standards such as what makes a good neighbor, standards such as standalone business. Judge Elsenheimer, and I would encourage all of you to read that transcript and come to your own minds about what his thoughts are on the case. Mentioned several that were applied last time, such as the size of the business and whether it brought in additional customers from outside as being irrelevant because they're not in the ordinance. And the reason, ladies and gentlemen, that's a due process issue, because you can't hold someone to a standard that's not in the zoning ordinance. And to the extent you do so, you rob them of due process of law. Third legal concept I'd like to talk with you about before I hand it over to Mr. Boyer is counsel has repeatedly now, both her and her predecessor in this case, Mr. Bisdock, asserted that somehow you can regulate what goes on offshore. And it's simply not true. You can't regulate what happens in the Bay any more than you can regulate what happens in Traverse City, any more than you can regulate what happens in Acme, any more than you can regulate what happens in Garfield Township. The Bay is not in East Bay Township and is not subject to zoning. Every case cited by counsel has to do with inland lakes. And with an inland lake, the property, the bottom land is owned by the adjoining owners. It's called riparian rights. It's a completely different situation than a Great Lake. Coast Guard may be able to tell us where the boats can go. State Police may be able to tell us where the boats can go. East Bay Township does not have the authority to regulate anything that happens on that side of the high water mark. So with those things in mind, I know this stuff has been rehashed and Mr. Boyer will be brief about it, but there are certain factual issues that should be refuted. Thank you.
Thank you for having us back today. With the limited time to respond, I just found out about this yesterday. I'm going to try and do my best to stick to the limit on the time here. I would like to address a couple of things that were mentioned by opposing counsel in her presentation before I go into mine. As far as the actual size of TC Water Sports, numbers that have been asserted are preposterous. We do not rent out boats 5 or 6 times a day. We rent out boats with a maximum of 2 times per day. We have 2 times per day that people can rent a boat. Most of our boats run out on a full-day basis. When they're not rented out on a full-day basis, they oftentimes run out on a half-day basis. That's 2 rentals of a half-day, a maximum of 2 times per day. Jet skis are not capped in the same way in terms of a maximum number of rental times, but when we're fully booked, we see our boats go out about 1 to 1.5 times per day, fully booked, not average day. It's just not an accurate representation. Comparisons of breaking waves, they are a similar size to TC Water Sports. There's been some confusion over the difference between the 1469 location that Breaking Waves currently operates out of and the Park Shore location that was contemplated by the site plan. Same business, 2 separate locations. One was treated as an accessory use under site plan. One was recommended to go through site plan because it operates out of a location not from a hotel. There are actually 4 businesses, not 1, operating from that location. The only reason why it was recommended that there was a site plan review for that location is because it was a change of use of the property. They were the principal use of the property, or presumably the principal use of the property, and because of a combination of uses. All standards found within the code requiring site plan. Breaking Waves does not operate out of the center of their property. It's been represented by Port Traverse. They operate along the property line, actually closer to the property line than TC Water Sports has. Those businesses are very similar to TC Water Sports in terms of the number of equipment, the number of boat hoists, the size of their docks, the type of customers, and really any and all of the potential impacts that might be presented by that type of business. They're very, very similar to TC Water Sports. The idea of what's at stake, TC Water Sports, if it is denied this accessory use, will be limited to a size that is smaller than what it was when it opened in 2014. So you would be effectively scaling back any growth in business that TC Water Sports has experienced over the last 9 years. That's what's at stake. Contrary to assertions by Port Traverse and their counsel, the fuel storage would still be subject to the fire marshal. We would still be regulated in terms of how we store our fuel. We would still be regulated by our dock permit. We would still be regulated by the Bottomlands resolution that the Planning Commission signed, which limits the size and scope of TC Water Sports operation. Those would all stay moving forward. The judge has asked that you provide evidence on the record as to why you think that the zoning administrator and his decision should be overturned. As opposing counsel stated in the last hearing, the photographs provided by Port Traverse are really the only evidence they've presented. They've stated in the recent memo that that evidence was irrefutable. Really, that irrefutable evidence amounts to a handful of pictures that were taken out of context, grossly out of context in some cases. The pictures you see on the screen were of the busiest day in the history of TC Water Sports. It's simply not an accurate representation of what our business is like any day up until that point and any day since. We don't really have time to go point for point over all the false assertions made by Port Traverse, but I would like to give you a couple examples of how easily refutable their allegations and misrepresentations are. They continue to claim that TC Water Sports only had 6 boats and 5 jet skis for rent in 2016. I've provided you with extensive documentation, including satellite imagery, photos labeling the location of every hoist, insurance paperwork from a third party that gives the in-service date of every single piece of equipment by VIN number that we owned and operated in both of those years. That, to me, is irrefutable evidence. Not a picture that is taken during the middle of a busy day when boats are away from the dock. And really, all that picture shows is what is the minimum amount of equipment that was at that dock at that very time, not the maximum. We've provided this documentation, and it shows that there were 12 personal watercraft hoists and 8 boat hoists in both 2015 and 2016. It shows that there were between 25 and 27 motorized watercraft for rent in 2015 and 2016. Very much to the contrary of what's been asserted by the opposition. Port Traverse has claimed that TC Water Sports somehow has as many as 500 customers per day. I can tell you, I've been doing this for 25 years. We have never had anywhere close to half that many customers, ever. More importantly, we don't have them all at the same time. Our customers come in waves. The way that our boats are rented, we've presented this in our memos extensively. We rent a maximum of 3 boats at a time. Based on the absolute maximum number of people that could fit on any boat, we would have a maximum of 54 boat rental customers at one time, plus 6 jet ski customers at one time. 60 customers, absolute max. Everything is completely booked to the brim. Can't have one more person. In reality, most of our customers are families with 4 to 6 people. We might have some customers who are a single person or a couple that run a boat, and we might have some groups that come out. But the majority of our customers are families. I don't know too many 16-person families these days. Maybe that happened more back in the day, but today most of our customers are 4 to 6-person families. There's been no evidence presented whatsoever to substantiate these wild claims. Nothing other than an allegation. And certainly not at the beach at the same time. And we've talked a lot in our memo about that and the importance of how many people are there at one specific time versus the entire day. In the 25 years that I've been doing this, I've learned my business better than anybody else. I know my numbers, I know my business, I know where they come from, I know what demographics they come from, and it really feels inappropriate to me to have a third party telling me how many customers I take in a day. I would like for them to prove it. How many customers do I take in a day? I think I've presented you guys with a consistent narrative of what we expect to have there. I've given you consistent representations of how much equipment we've had that are well supported and well documented. For all the reasons that we've covered previously, TC Water Sports clearly meets the definition of an accessory business. And really the only substantial difference between TC Water Sports and other boat rentals in the area is how we're treated. Our impacts are similar, our sizes are similar, the number of watercraft we rent is similar, our proximity to the property line is similar. The only difference is we're the only boat rental in Traverse City and the only boat rental in East Bay Township that has a dock permit that's valid. We're the only one who has a bottomland lease that's valid. We're the only one that has been subject to a bottomland resolution by the township that's valid currently. We're the only one that is currently subject to site plan review. We're the only one being required to present evidence to stay in business or stay a valid business that isn't forced to shrink in its operational size. We just ask that the board consider the evidence that we've provided, and all we want is to be treated fairly under the code, have the actual code be applied to us and our business, and to reasonably expect similar treatment with similarly situated businesses. If this board decides again without evidence, we will have no choice but to challenge this again. And we really don't want to spend any more of your time or the taxpayers' resources. We don't want to spend any more of our own financial resources or time hashing through this, but we're prepared to do that if we have to, because we want to uphold what's ethically and morally right, and to be treated fairly is the minimum that we should expect. Thank you.
Thank you. All right. Before we go into discussion, we excuse me, said we would open it up to any public comment following their presentation. So is there any public comment out there, which opens up at 7:05?
Good evening. My name is Magdalene Paddock. I'm a Port Traverse resident for over 30 years. I've been here before. We've been through this discussion before. But I do want to say how much I appreciate township officials and the ZBA who have been addressing our concerns regarding TCW's accessory use status for the last few years. We appreciate the countless hours and time you've taken and looking at all the materials, and there's a lot of materials. The last packet was almost 900 pages. The residents of Port Traverse respectfully request that Number one, you reconfirmed the 2021 ZBA determination that TC Watersports does not qualify as accessory use. And number two, you respond to the circuit court's request and adopt findings of facts that reflect the evidence that we have provided to the ZBA that substantiate this denial. Our counsel has clearly outlined this evidence, which includes the explosive growth of the number of TCW rental watercraft and their client base. This is not insubstantial, and that is a term that is used in the finding of fact and in the definition of accessory use. As recognized by the ZBA in 2021, this growth and intensity of use at our property line has impacted Port Traverse, and these impacts are more burdensome than having the regular operations of a hotel on our boundary. Residents of Port Traverse enjoy spending time on our decks and our beach, and for 4 months a year, 7 days a week, 11 hours a day, our enjoyment is overshadowed by these burdensome effects. Noise by more than 20 combustible engines operating on our property line, health and safety issues related to gasoline, trespass, which our council has gone through in great detail. But we're not talking about beach walkers, we're talking about consumers that are coming to TC Watersports. Their operation hub was right at our border. They congregate there, they fill out the paperwork, they select their life jackets and get other equipment and wait for the boats. So that is an area of congregation. It is important to note and reiterate, this is, TCW operations is not an insubstantial part of the total activity that takes place on these grounds of Sugar Beach. And it does have more burdensome effects on Port Traverse than the regular operations associated with the hotel. For these two reasons, we feel that TCW is not in accord with the East Bay zoning ordinance definitions for accessory use. I didn't see our council's packet, but I have the same picture that she had in hers, which showed the TCW's operations on our boundary line. This is our fence, these are our condos, these are our decks, and this is the hub of the activity that takes place right on our border. If TCW gets accessory use, we're afraid this is going to come back, and we're not going to have the setback. TCW has argued that other rental operations have advantages that TCW doesn't have. I think the biggest disadvantage for TCW is that they are having their operations right on the border of a residential community.
Excuse me, your time is just about.
Okay, and that is something that you do not see with Breaking Waters. That's not a residential community, and there's a much greater setback. Thank you for your time.
Thank you.
And consideration.
Thank you. Anybody else? Okay. Seeing none, we'll,
Jeez.
Good evening. Thank you again for being here this evening and going through our packet. Sally Somso, 1717 US 31 North, Port Traverse. One of the things that we just heard again this evening is they have always been this big. They've always been this big. We keep saying that we thought they were smaller in 2014, 15 when they started down there. But they've always been this big. And today, this evening, now we're hearing that, well, if they have to go back to what they were, then they're going to be smaller than what they were. I'm totally confused now, but hopefully you understand what they were talking about. The pictures, not all those pictures were of July 4th, 2020. Some of them were from 2017, with all of the people standing out on the dock. Totally unrelated photos like that. We had 12 paddleboards out in our swimming and bathing area. Somebody was giving a lesson from TC Watersports. Those are the types of things that we have dealt with for the last 8 years out there on the bay. I have no idea where they've come up with the numbers that 60% of the customers are registered guests of the Sugar Beach Resort. Where did the numbers come from? Where are the 20% of the other area hotel guests that come down the beach to TC Water Sports? And 20% are driving individuals who either call, register online, or just show up. To validate their parking numbers, they state that 40% of the hotel customers check out each day, leaving 40 parking spaces. Yet most weekends, there are very limited, if any, parking spots, and TC Water Sports customers are parking at Port Traverse or across US 31, dodging traffic when they park at Pirates Cove, the old Pizza Hut lot, or Smokin' Porter. Since these spots are directly across the street from Port Traverse's entrance, they come across the road, dodging traffic, with their coolers, food, bags, and other items through our parking lot and down to the TCW spot. They have proclaimed that their numbers are low in regard to customers using their watercraft. They have made concessions. They did away with the Paracel business. It's still listed on their website in a very prominent position. Not available summer of 2022. So will they bring back this service in 2023 or 2024? This boat is certified for 12 passengers. They advertise that they have more than 100,000 satisfied customers and that the new-to-them Paracel boat joined their fleet in 2018. They have indicated that their boats do not operate at capacity, yet while trying to justify the size of their dock down to the former Irish boat site, they state to the Eagle that their boats could have as many as 15 youth, children, plus adults. My direct observations indicate that many boats have 7 to 10 individuals on board, and I have seen boats with only 5 people as well. Remember, these customers visit the location, arrive early to check in, prepare for their trip, etc., go on their trip out into the bay and return, so each person visits the site twice. And there's hardly boats at the dock from time to time, and there's like a continuous turnover, also bringing in, boats from other areas that come into the dock, go into the circuit, and load, unload, load, unload. So, thank you very much. Good luck for your decision. I know this is going to not be an easy one, and thank you for your time.
Thank you. Last chance. All right, we're closing the meeting, public hearing at 7:13. All right. We'll take it back to the board for discussion, and any questions of either council will ask, and please come up and take part in the discussion. All right?
Mr. Chairman, if I may just...
Please, if you would, Peter. Thank you.
I just want to outline, I've provided the 3 possible choices here. The biggest issue with the way the ordinance is written has to do with section 2212C, which states that if it is determined that there is an accessory use, any accessory use shall not generate any effects on neighboring properties, including but not limited to noise, parking, traffic. I don't think glare and dust was really an issue in the discussions here and the evidence. The gasoline was, transportation over the ground, greater than or more burdensome than such impacts from the main use of the property. And that's why you have 3 choices instead of 2, because you can determine under the ordinance that the use is in fact an accessory use within the RB district, but still determine that as an accessory use it generates effects on neighboring properties such as noise, parking, traffic, or the allegation of pollution on the transportation of fuel to the extent that you believe the evidence is there. That is greater or more burdensome than such impacts from the main use on the property. You can also determine that the use is not an accessory use, and even if it were, you could still delve into section 2C, which I recommend to have as complete a record as possible, again, if you're going to go in that direction. And of course, you can determine that it's an accessory use, and that the accessory use in of itself does not generate any such effects as provided under section 2C. A couple comments from the attorney's presentation. Mr. Zayas is correct regarding what goes on once the boats leave and are out on the waters of Grand Traverse Bay. You're focusing on what occurs on the shoreline and on the property itself. In fact, Article 2C of Section 221 talks about what's going on as far as impacts from the main use on the property. So on the property is key throughout your deliberations here. We're not going to worry too much about what goes on once boats are, intermixing with other boats on the surface of Grand Traverse, or East Grand Traverse Bay. The other comment involved the request that the suggestions regarding the minutes be made part of the record. It's part of the record of these proceedings. It is not part of the record of any appeal, should an appeal occur, because we had a deadline regarding submittals related to that. And furthermore, any party, and I've been through many of these meetings, can certainly bring in a court reporter, and they wish to have a word-for-word courtroom type of setting and hearing as to what goes on at the meeting, then the court reporter's information would be presented along with the minutes, and the court would use that, and the law is clear that that's allowed. But absent that, the board speaks through its minutes and its findings, and the time has expired for presenting any more information other than what the board allowed tonight as far as attorney presentation. So if you have any questions, regarding your decision as we go along, feel free to ask the applicant, or the appellant rather, and the TC Water Sports or me, and we'll go from there. The purpose of my outline was to try and make things a little bit easier and organized for you as you go through the decision-making process here. I do ask, though, because there's a category, if you look through your findings, that you at least pick one in each of these categories here. Of course, we have the general findings of fact, which are general, and a couple of neutral ones, which are in there. But I start off, with the definitions section of 2211, and those are the findings addressing that specifically all the way through about a third of the way through page 6. And then I start delving into section 2212A, all right, and findings related to that. So I'd like you to make sure you pick something out of that or create one of your own. And the same with 2B and the same with 2C, so that we have a finding on at least those 4 items, or multiple findings on at least those 4 items, so that the court has an idea, should this go to appeal again, what the decision was and why it was rendered. Exhibits are attached to those findings, and so those exhibits go along with them, which includes the materials from both TC Water Sports as well as from the Condo Association as well. So that's basically how this operates. This is de novo, right? It's true it wasn't reversed, it's remanded back to you, but it doesn't mean that you have to make the same decision you made before. So you're basically making a new decision here based on the evidence that was presented to you back in December and the written materials and today as well.
There has been a number of times discussion has been with respect to 2 other businesses on the beach, one being Breaking Waves and the other is the Blue Sky Rentals. But I would just say that for our purposes and our discussions and our determinations, the facts and the circumstances deal with this issue alone and nothing else.
It is true, but the facts that those businesses exist are part of this record and were brought in there. So part of how you look at accessory uses is often by looking at what's occurring within the same zoning district.
Okay.
So it can be considered. The uniqueness, perhaps, is most prevalent in your findings under section 2212C, and whether or not, even if those other uses are considered accessory and therefore this should be considered accessory, does the accessory use, even if it's considered an accessory use, generate any effects on neighboring properties, including but not limited to noise, parking, traffic, et cetera, as we talked about, greater than or more burdensome than such impacts from the main use on the property. So that's why you have the, potentially the 3 choices there. But no, nothing prevents you from looking at what's occurring in the RB zoning district and its history of what's gone on there. Just in the same, nothing prevents you from looking at how this operation impacts the neighbors, particularly under the way Section 2C is written.
Good, thank you. Does the board have any questions for any of the councils?
I got a question for Peter. Kind of back on the topic of the township's ability to regulate what goes on the water. I guess I understand that part. Where's the delineation on the dock itself, on the physical dock? Does it stop at the high water mark, so anything on the dock and on the water? Or I may be splitting hairs here,
Well,
but,
the dock is connected to the shoreline.
Right.
So I'd venture to say that the dock itself is part of what you're looking at. But once those boats are let go from the dock and they're on the waterfront, what they do out there, and whether they rev the engine or don't rev the engine or drive, in front of one property or another, is not part of their consideration.
okay.
Questions, comments?
I guess I would start off in reference to, I think it's 1402A, about the accessory use. I think in the fact that if I was going to go to Sugar Beach as a customer, and I walked out back and saw a boat rental there or someplace to rent a boat, I would look at that as being part of what I would expect. So I guess, kind of looking at it from that way, I would say that that would constitute an accessory use of that business. So that part, I think, as far as I'm concerned, or my 2 cents worth, is that that's an accessory use. When we start getting into the 221-2C, with the noise and the dust effects, I have a problem with the noise that is generated primarily at the property line where their shed is, if you will, and as Matt says, possibly on the dock. If there's noise on the dock, that's a lot of noise coming from the docks, and we have the ability to regulate that, or at least look at that as being something that is adverse to the residential property of Port Traverse, then that would probably add to my thinking that the noise is a problem as far as 221-2C is concerned. The other stuff with the gas, I don't think that much gas is traveled back and forth per day. Fire Marshal has approved that. He's approved the trailer. What's on the water's on the water. If I want to pull my boat up 50 feet in front of Port Traverse, anchor it, and have lunch there, that's my right. So I don't think the water has any part to do with it. People crossing the road, that's at their own choosing. Certainly trespassing on Port Traverse is a legal issue, and I don't think that comes into effect as far as I'm concerned. We're looking at accessory uses for this business. But that'll start a conversation.
Okay. Well, the only question about the parking would be where they park. I mean, if they're parking across the street and walking over, it's one thing. If they're parking in Port Traverse property, that's another, and that would definitely fall, I think, under 2C. That's just an opinion. Rod?
Well, you know, I'm really struggling here. I feel somewhat the same way. It's probably an accessory use, but there are so many things going on, noise. I still struggle with the concept of number of people. I did spend quite a bit of time myself just going to TC Water Sports webpage on the web. Here's what you're advertising. The numbers, and actually there's the pages, the numbers per boat are much larger than 4, 5, or 6. The other thing is that I found if I clicked on boat rentals, it says nothing about having to rent for a half day or full day. As a matter of fact, it pops up, you can rent any boat for 1 hour. I don't know that I would do that, but right on their own boat rentals, You pick any pontoon, whatever, any of it, even the jet skis, and they pop up with a schedule starting at per hour, 4 hours, 8 hours, 1 day, 2 days, 3 days. And my other thought in that was, I don't see any operation hours, and we heard that there's 11 hours a day. There's actually a coupon on their website that if you rent before 11 a.m. in the morning, you get a $5 discount per hour. I don't know if you can rent at 7 in the morning and do a morning cruise, and you're still open at 9 at night. So I just, that their boats are only rented 1 or 2 times a day doesn't fit what they put on their website. And I'm taking it right from their website per hour. And the jet skis, you can rent 1, 2, 3, 4, 5, 6 hours. I mean, it's unlimited. So that really just doesn't set with me, and I think that puts a lot of burden on the local parking, the local community, the local neighbors.
Just for the record, I did look on their website, and I did see hours from 9 to 9. So,
Did you?
Yeah.
Okay,
So there was one spot, maybe I was lucky, but I found
okay,
the
9 to 9 is 12 hours.
It's 12 hours, right.
Okay.
Okay.
Thank you for clarifying that.
No, just,
But yeah, 12 hours is, and
It's
so
still-
you break it down and somebody says, I want to rent for 3 hours. Well, they're not going to let any boat set for, a lot longer. When you got 12, that's at least 3, 4 rentals a day.
Well, I guess in dealing with this for a long time, a number of meetings, a lot of discussion, a lot of presentation, I think our packet is huge. Like was mentioned tonight, it's almost 900 pages, plus everything we've reviewed before. If you really kind of step back and look at a lot of the information in there, there's a lot of circumstantial information. There's other maybe other examples that aren't necessarily this particular case that we're hearing tonight. And then there's a lot of, maybe speculation and opinions about noise levels, the amount of people. There's photos and arguments on either side. Presentations discussing how many people are here to kind of give us an idea. Not that the quantity of people is really relevant here, but it would give us some ability to try to put our arms around what that impact might look like. But we haven't seen any documentation presented to us that shows records of how many people rented. I'm sure that's probably available or somewhere. So at this point, that information is good, but it's tough to make any real sausage out of it at this point for me. But what we do have are a few things that are very black and white, in my opinion, and factual. And, a couple of things that I'm kind of keying in on when I start thinking about accessory use. Could this operation be considered an accessory use? Well, yeah, it could. But under our ordinance, could it? The ordinance states that it must be associated with the principal use. Could it be associated with the principal use of staying in a hotel? Maybe. Principal use and integrally related to it, and integrally. So it has to basically satisfy both of those, in my opinion. And I guess, I'm not a world traveler, but I stay in hotels in different cities, and I would argue that there's probably 99.5% of hotels that operate around the world without boats and docks. So is it integrally related to it and commonly associated with the principal use of a hotel per our ordinance? It'd be tough to make that argument, I think, just strictly looking at our ordinance. So for that reason, I'm struggling with it. I would also say that of the sort of the black and white evidence that I can take away from this is I see a huge number of individuals that have spent, on the applicant side, have spent quite a bit of time and resources engaged in this, and I just struggle with the idea that all of these people would have, an axe to grind with TC Watersports. I would think that with the time and resources put into it, that is evidence enough to justify the impacts that are being expressed per our ordinance, the noise and other impacts that are defined in the ordinance.
Lindsay?
So this is a bit of a struggle for me, too. I agree with what you were saying about being integrally related. That's a good point, but coming from, anybody can have a neighbor where they don't like something that they're doing, and there can be a number of complaints. But for me, it's really like having some evidence. Has there been a noise study that this is in violation of the ordinance? Are they operating outside, like the hours where the noise ordinance would even be put into effect? Have they been considered a nuisance? I also agree that I would like to see some records of rentals so we could actually quantify the people that were coming here, because while pictures are helpful, was that taken on July 4th, during the busiest day? There's just, but I do agree with the integral part that you were saying on there. And I did look at the website and see the 1 hour rental minimum. So it's a tough one. I guess for me, like I said, has there been a noise study? Are you aware of anything that's been done, Preston? And I think I asked the last time, they haven't gotten any violations as far as tickets go for being a nuisance, or from the sheriff's department, or anybody being out there for trespassing or violating.
Firsthand knowledge of, no.
So that's what makes it difficult for me. I work with people all the time where neighbors aren't happy with things, and of course we want to make everybody happy, but I'm just trying to find a quantifier for some of these impacts.
Mr. Chairman, just,
Surely.
I think you've done now your first round, and I just want to point two things. You're right, we have to look at the record, 2 comments, because your decision has to be based on the record. And I asked Preston, I don't recall there being any discussion of parking in the condominium association parking lot as part of the record. You just mentioned it, but I don't remember that.
There is.
There is.
It's mentioned.
Was it mentioned in one of them? Okay, so that's fine if it's in there, that it's in there. And then the other comment is that we're looking at accessory uses, but you have to keep in mind it's in the RV district here in East Bay, not, I know that the applicant also, or not the appellant, but TC Watersports, in one of their papers that talked about what happens in Grand Traverse and, at large on the waterfront area, but we're focusing on accessory uses just in the RV district, not elsewhere.
Okay.
That's all.
All right, thank you. Since our last meeting, I think I've read this section 221 about 3 times a day, just going through it, working on this thing. And I share with you the same questions that go through my mind, and that is, a lot of it comes down to how many people are we talking about? What is the number of people that are there? And we have, honestly, 2 extremes. We have one person saying it's 500 people a day, and another person saying it's, 45 people a day. I did a couple of things, like all of you. I looked on the website. I was looking at items. I also looked at the comments, people's valuations. And it was interesting that a good majority of the people who were commenting, plus and minus, had taken out the jet ski for an hour. They had been there, they were curious, they wanted to know what it was like, and they took it out for an hour. That was most of the comments that I saw. I did see some that they had rented for a day, but we won't go through that. Not jet ski, a boat. So I was like gathering in this type of information to figure it all out. I did the calculations based upon the narrative that was given, and I thought to myself, you're not making money. I mean, you don't have that few number of people doing that type of thing. However, from a standpoint of the ordinance and talking about being an accessory use, okay, we have a hotel and it's on the water. So from a standpoint of having that type of amenity to a hotel, yeah, I can agree. I can see that. I can well understand why you would have that type of amenity, and it would be useful. Is it absolutely positively integrated into the hotel? That's kind of hard to say, but still, I can see it as being part of the amenities of the hotel. Where I trip over our issues is, certainly Section 2C, and that's where I have my problems. But again, I would like, well, I would like, but I don't have, I would like to have seen more information, more concrete information, certainly on the use of the facility, how many people we're talking about. The other discussion point was that that this, is no different from the hotel as far as the number of people on the beach at the hotel. And some number was used that, on average, people spend 4 hours on the beach. Well, I don't know that. So, that's kind of a long stretch of time. Maybe when I was a kid, I'd do it, but not now. And the other thoughts was that when I looked at this thing, you look at the beach, and these folks are spread along the whole beach, and I don't know how big that property is. 100 feet, no more than 100 feet, 200 feet, 300 feet, 300 feet. So that's a long stretch for a lot of people to be there and not concentrate on the noise. I mean, that far away, I could be playing radio and couldn't really hear it that much. But on this particular issue, you're now taking all these people and concentrating them in a smaller space right next to a residential area. And that's one of the big differences between this particular business and the other two. We're talking something right up against a residential area. And when I see where the booth or the hut was, I can readily understand why you would have that congestion and that noise and that congregation of X number of people during the time or during any particular time, but on a constant basis for a 12-hour business day. And of course, I'm not saying that you have that many people all the time, but it is a concentration of time. So I can readily see the argument that it is accessory, but when I look at the ordinance and what actually constitutes the accessory, I trip over the last section, which is 2C.
But, Chairman, that's exactly correct. The 2C member is actually a sort of a separate standard. It is unique. It's a different standard because it says an accessory use shall not. So it means that if you've determined that it's an accessory use, even if it is one, it shall not do these things. That's why you have those three choices. That's what, it's a strange section. It's different from 2A and B as far as how you determine whether it's an accessory use, but it has its own standalone property where it says an accessory use shall not, meaning that if it's an accessory use, it still can't do these things.
And that's why I trip over it.
Yeah.
Okay. And I...
On that with the ordinance provision.
Yes, that went through, that went through my mind, and I'll have to prevail upon the subcommittee to be looking at this when it comes time. In the way to proceed, should we be, and I'm going to ask counsel, should we be taking each section of 221 and coming to some decision on each one of those sections?
Yes, okay, but in the end, it has to end up so that it's consistent, in the end. So, but yes, I do want, there's general findings of fact. If the board is agreeable to that or wishes to add something, you can dispose of that quickly. You don't have to read everything. Everybody has these findings. There's actually a couple other corrections in here, but that it's minor, that can be fixed. If you wish to add any, or if any board members brought any findings in with that reference exhibits, they can certainly add that or make their own changes and discuss changes. But I would start with making sure everybody's fine with the general findings of fact. Moving into the section 221.1, which is as I mentioned, all the way through until about the top third of page 6, and then you move on to 2A, 2B, and 2C, and at least have a finding that you can choose under each one, and that's why in the email I gave you the findings that match up to an ultimate result that this board may take.
Okay, so then I would then ask the board, you've had a chance to read over the general findings of fact, items 1 through 12. Is there any comment, any modification? Do you all agree that those general findings of fact are in fact what you see and what you agree with?
Do we need a consensus or a motion, or how do we proceed with this?
Do we need a motion to take?
You have to have like a consensus that'll be part of the record and
All right. So is everybody in agreement, or is there any questions about it?
I personally don't have any issues with 1 through
It's just
12.
statements of fact. I don't see a problem with it.
Neither do I.
I agree. Yep.
Yep, okay, thank you. Then we'll move into the actual section itself, 221. Item 1 on section 221 is primarily a definition of what the example or just discussion of accessory uses. I don't see anything that was particularly jumping out at me there, that particularly that it, number 1, constitutes only an incidental or insubstantial part of the total activity that takes place on a lot, and number 2, is commonly associated with the principal use and integrally related to it. So, from a definitional standpoint, I don't see any problem with this.
I agree with you, Paul. That is basically what we're ruling on.
Neutral finding 1 and 2, I think they're fine.
Fine. Yeah, well, we're looking at section 221, section 1.
Right, okay.
So it was really, as I said, it's more like a definitional type piece as to what's laying the groundwork about what we're thinking about, what an accessory use is. On the number 2, though, on the interpretation of accessory uses for the purpose of interpreting accessory uses, and I'm going to read it. A use may be regarded as incidental or insubstantial if it is incidental, insubstantial in and of itself or in relation to the principal use. 2, or B, is to be commonly associated with the principal use. It is not necessary for an accessory use to be connected with such principal use more times than not, but only that the association of such accessory use with such principal use takes place with sufficient frequency that there is a common acceptance of the relatedness. And C, an accessory use may not, okay, that's C, A and B is where we are. And then C is an accessory use shall not generate any effects on neighboring properties, including but not limited to noise, parking, traffic, glare, or dust greater than or more burdensome than such impacts from the main use of the property.
And those findings actually begin on page 6. So you have the definition section 221.1. Those are the rest of the ones on 4, 5, and then finishes up in the top 36. Go to the 2ABC after that.
I found, I thought finding 14, um, 11, well, I should go in order. 11, 12, and 14 were the ones that came out to me.
You say 11, 12, and 14?
Yeah, 11, yeah. 11 to a lesser extent than 12 and 14.
Yeah, 12 just is an introduction for that neutral finding.
So Paul, can I ask a clarification? When you say that they come out to you, like, you're finding that it's not supporting the accessory use because it's generating more noise impact? Is that what you're saying with
Yes,
that last
I'm
statement?
saying that I concede the fact that this service could be part of a hotel's overall services. In some cases, when it's a small part of that service, incidental to the hotel's other services, I concur. But I have a problem since where this is the residential piece, that it is in fact generating that noise, et cetera, dust and all the rest of that.
Thank you. I just wanted to make sure I was understanding.
Yeah, that was my thinking.
Just keep in mind as you look through these that, on the accessory use, it's not so much the size of the accessory use itself. That may have a big impact on your decision under 2C, but you first determine, is it an accessory use, all right? If it is an accessory use to begin with, you can still look at, obviously, 2C to see whether this type of accessory use would otherwise still not be allowed because it generates these types of effects. But we do have to determine first and foremost, under both Section 221, the definition, and it's a bit of a repeat, I know, under 2A, of whether it's an accessory use. I'd prefer to see you get that behind you before you tackle 2C, that's all. Because we need findings on all that stuff before it needs the record.
I've already stated my position, so.
So you said you need a finding under specific findings of fact 2A?
Yes.
Under section
That
2A?
begins right at the very bottom, of 3. I mean, you have 1 and 2 there on page 4 that are neutral, but, the real important ones are, 3, 4, 5, 6, and 7. And then we head into B, which is 221, 2A, and so forth. But I need something on each one of them. The court pretty much demands that, and that's what we're looking for. Like I said, you can pick and choose out of those, but I just need something, the board needs to have a decision on that issue, on these different sections. Definition 1, and then 2A, B, and C findings for each one. So at least a minimum of 4 findings that are cohesive in one way or the other. That's why I gave you those 3 choices, because you can still find that there's an accessory use there, but in this, that 2C applies, and therefore it shouldn't be allowed, or you can find that it's an accessory use and 2C is not an issue, and it's fine that way, which is a, TC Water Sports, talked about.
I guess, Paul, are you taking suggestions here?
Yes, sir.
So section 221A, finding of fact 7, I'll read it. The board finds that similar uses of hotel properties in the RB zoning district include such uses as restaurants within existing hotels, which the zoning board of appeals notes also serves guests other than those staying on any given hotel property. However, the board further finds that the boat rental business by TC Water Sports at the property includes transfers of boats from off-site facilities, further concentrating the use on the waterfront of the property for customers, which at this juncture are not necessarily hotel guests, including the movement of boats and the pickup of rental boats from off-site areas being brought to the property site. The board further finds that the use is substantial and concentrates as a primary use on the beachfront of the property during the warm season, generating the most noise and impacts on the beach compared to any other use on the waterfront of the property. As such, the board finds that the use is substantial and dominates the activity on the beach of the property, which is a primary feature of the property. The board further finds that the use did not exist when the property was initially approved and built in '94, and that the use, when introduced, was limited in scope and was for the benefit of resort guests only until it expanded sometime after 2007 to a use which operates as a principal use and a standalone business. The board further finds that the jet ski and boat rental use is not accessory to the principal use, and the boat rental was not considered under the site plan for the property when approved for construction under zoning in 1994, unlike the Park Shore Resort and Cherry Tree Inn. As such, the board finds that the use is not an accessory use, as the use is not commonly associated with the principal use or integrally related to it, in that the use would have otherwise been considered as part of the primary use with respect to the parking, et cetera, as was done with Cherry Tree Inn for the spa and the Park Shore Resort for the jet ski rental.
Comment? Looking.
One comment on, to kind of clarify on this finding of fact 7 that I just read. I'm about 3/4 of the way through it on page 6. I just wanted to double check myself. The finding of fact states, I don't know, it's like line 7, finds that the use is not an accessory use as the use is not commonly associated with a principal use. It says, or integrally related. The ordinance says, and. I don't know if that's something we need to correct.
Yes, you're correct on there. So go ahead and cross that out and put and.
But that, I guess the reason I support this one is it kind of goes back to my comment about that part of the ordinance.
To the intricately related piece of it.
I would agree with you, Matt. Which then also, I guess, I would support 7 and then 3. Not in support of an accessory use.
I would support that as well.
You mind repeating that? I've got 7, but we're talking about.
Number 3,
On page 4.
page 4, number 3.
Oh, okay. Well, in a different direction.
Yeah, number 3 gives a nice piece of history.
It does.
Any other comments from the other members?
I agree with 3 and 7.
John?
Yeah, 3 and 7.
Okay. So under, correct me if I'm wrong, Counselor, but under section 221, 2A and B,
That's what we're moving on to. You've just addressed section 221-1 on those findings.
221, 1, okay, now on 221, 2.
It says B under interpretation of accessory uses 221-2A, so if you could make a finding on that as well, probably best to be consistent with.
Starting on page 6.
Page 6, middle, under
Yep.
B.
Again, feel free to edit or make changes as needed. You're reading there, in any of these findings.
I will say this, so far I found that 9, because it also talks about the hourly and other short-term basis of rentals and so on. I would throw that out there.
Yeah, I would agree with that.
9.
Yep.
I had the same question for Peter on line 4, I believe it is. Board further finds the accessory use is neither insubstantial or incidental. Should that also be?
Should
and?
be and incidental. Good catch.
No, I mean, it means the same thing, but I can combine it for you. The and is not. Is better, probably.
I agree with 9. That revision.
That'd be with and is not. Is that a revision?
Do I now?
And is not is what I suggest there instead of or,
Right.
if you're going to make that revision.
Well, I think my point with the other revision was that it was, it aligned with the language in the ordinance.
Correct.
Which was the difference between.
This one's
and
more
and
of
or.
a paraphrase.
Okay.
I just want to make sure the sentence works, that's all.
Okay.
I'm sorry, could you repeat what changes are you making there?
I'll read it again to you to see if that's to your satisfaction. The board further finds that the accessory use is neither insubstantial and is not incidental to the primary use of the property, given the purpose of having the resort, given the purpose, should be probably a better sentence, that the purpose of the resort is a waterfront use. Or you can just get rid of the whole sentence if you wish it.
Peter, is there an issue with the numbering? Because there's a 9 and a 10.
Yeah, I already went with, I
Oh,
already
I'm
pointed
sorry.
that out.
Okay.
They have those corrections.
Okay, so item 9 is a finding for section 221-2A. All right, 221-2B.
I agree with number 11 under 221-2B.
That's where I would put it.
Yes.
Rod?
I'm fine with 11.
Yeah, I'm good.
Okay. So 221-2B would be item number 11, and finally 221-2C.
C should be, will be put in there, the C is missing, but that's what it is, yes.
I find 12 and 14.
Yeah, I would agree with that, Paul.
Oh, you're saying both 12 and 14?
12 and 14.
Okay, all right, I agree.
I agree. In 14, there's an equal sign about mid-paragraph of the last part of, on page 9. Just a typo.
Yeah.
And that was also true in 11. Under water sports, there was an equal sign at it on number 11, kind of right in the middle. I'm picking up little things, I'm
No,
sorry,
that's
but,
true. There's also a couple of ampersand signs, so I don't know how those ended up in there, but we'll get those out of there.
okay. I don't know if that matters here, but,
In item 14, I noted in the other, when we're talking about not in support of it being an accessory, we note that the rental is to the general public in addition to the resort guests, that it's not exclusive to Sugar Beach. Should that be part of 14?
You can add that in there. if you
Could
want.
add
I mean,
that in.
that's a big part of my reasoning, so for me, that's
Finding, sure.
important.
You can do that.
So we'll add that in there?
Sure.
It makes
Say
it.
again to me, where is that, so we can?
When we talk in the other items, like in 11, and I think there was a few other things where it talks about the rental to the general public in addition to the resort guests, that it's not exclusive to the resort itself. That be included in 14.
Would that be right after the board finds that the jet ski boat rental to the general public as well as?
So like the first sentence in 11, the board finds that TC Water Sports rentals are of a scale significantly greater than similar uses considered accessory within the district, given the number of watercraft available for rent, both motorized and non-motorized, and the availability of watercraft for rental to the general public in addition to resort guests.
Correct.
And it would be the same exhibits then. Okay, you can add that if you wish. The rest of the board wishes to add that.
Yes.
Mike, just please note, Peter, that there's actually 3 equal signs in that
Oh, no,
paragraph.
There's more than one.
There's some symbols that popped up when it got emailed out, which I don't know. We do use an older, what lawyers used to use, but nobody uses it anymore. It's called WordPerfect. And that could be part of the translation.
It's old.
That's old.
It is.
Okay, 2C, we have 12 and 14. Is there any other additions or corrections to either of those?
Nothing further.
John?
I'm good, thank you, I'm sorry.
Good?
I'm good.
Good? And Matt, you're good?
Yep.
Okay, we're good. Okay. So we need, at this point, we need to have a motion?
Yes, and the only thing I'd add is because you've incorporated both here, I mean, it's just a basic motion on here, appears from the findings of fact that the board would determine that it's not an accessory use, but I would want to add in here after, on the third line down, the motion within the RB zoning district, and in that, and the use generates effects on neighboring properties, and then use the 2C language for the rest of the.
I'm sorry, what number is that?
That would be on the motion itself.
Constitute,
Yeah,
can you read that back to us? Constitute,
yes, that the motion made by whoever and seconded by, and based upon the general and specific findings of fact and supporting exhibits, the TC Water Sports boat rental business at the Sugar Beach Resort does not constitute, I think that's where you're heading, an accessory use within the RV zoning district, and that the use generates effects on neighboring properties, including but not limited to noise, parking, traffic, greater than or more burdensome than such impacts from the main use on the property, per section 221 and section 412, which is the zoning district itself of the East Bay Charter Town. I don't believe there's any exception in the record of glare or dust that would be in that section. So those examples, of course, under 2C are included but are not limited to those examples. Findings and in the materials presented.
Okay, I'll accept the motion.
I'll make the motion of what Peter just said. Is that allowed?
Yeah, and I can read it again.
Please.
The motion
Please.
is by Kivold, and someone's going to second it, that based upon the general and specific findings of fact and supporting exhibits, comma, that TC Water Sports boat rental business at the Sugar Beach Resort does not constitute an accessory use within the RB zoning district, and that the use generates effects on neighboring properties, including but not limited to noise, parking, and traffic issues greater than or more burdensome than such impacts from the main use on the resort property, per section 221 and section 412 of the East Bay Charter Township zoning ordinance.
support.
Okay, the motion made by Ron and supported by Matt, as per reading by Peter. May we have a roll call vote on that?
Yes. Peter, can I just ask you a quick question? And I apologize if, just wanted to make sure. Do we need to go back and just have someone as a part of the motion specify the finding, the numbers that they approved, just to make sure?
They already approved it here, so the
Okay.
minutes are going to state that, and so
Okay.
the other items will.
Each
be
number will be a
eliminated.
part of, okay.
Yes.
Okay.
So those numbers are in there because they've already made approvals, which will be reflected in the minutes, because the findings they've adopted are the ones that they've chosen.
Okay, perfect.
That are consistent with the motion they made.
Okay.
Are we clear on which ones those were?
I just wanted to make sure everyone.
Okay,
knew
I have, so just check me on that. I have under section 221-1, it will be number 3 and number 7. On 221-2A, number 9. On 221-2, number 13 and number 11. And on 221-2C, be number 12 and 14 as modified.
As well as the neutral ones, number 1 and 2.
Well, I don't have 13. I had,
Neither did I didn't have 13.
I didn't have 13
I did not
either.
have 13.
I had 3, 7, 9, 11, the neutral findings, which included.
Did I say 13?
14. You did.
I'm sorry, I mean 14. I correct myself.
Okay.
Under 221-2C, it'd be number 12 and number 14 as modified.
There you go.
Thank you.
Perfect.
Okay.
If
You're right.
you'd like, you can incorporate, we can leave the other items in there, so the motion can be restated to add that in there if that's your preference. I don't think that's a bad point now to think of it from Claire. So, but it would just be specific findings of fact, 3, 7, 9, 11, 12, and 14, as well as the general. So that's fine.
Okay.
That way I don't have to change the numbering system on there, and the court can see what the options were to begin with.
Okay, so once again, it would be 3, 7, 9, 11, 12, and 14 as modified.
Is that?
And I will support that.
Can you
I,
restate that motion, make that motion again?
start over. Okay.
All we're doing is, it's the same motion, except.
Yeah, I make the motion that we, based on the general and specific findings of fact and supporting exhibits
Being
being
findings of fact, and then I think it's going to be right after that, specific findings of fact.
finding of facts, 3,
7, 9, 11, 12,
14,
and the rest is the same.
and the rest is the same.
Except for that additional language that you had.
Correct, which
Right.
we've already incorporated there, which includes the language essentially of 2C. And that comes after the word district on the print here.
Okay,
Okay. Now a roll call?
Support.
okay.
Okay.
The original motion was, you approved the amendment, right?
Yes.
Okay. Wolf?
Yes.
Ewan?
Yes.
Gonzalez?
Yes,
Cook?
Yes.
Kivel?
Yes.
my thanks to the board. This has been a long one and tough one. Thank you. All right. Okay, reports from the Township Board. Matt?
Yep. Happy New Year from the Township Board. We had a meeting last night, pretty lengthy. A lot of it centered around reports, particularly from the Road Commission. They had some conversations about some patching and repairs. Their plan, their maintenance plan for next year. I think they mentioned that was going to be available on their website, along with, I guess, some new software that they're going to be using. I thought it was pretty interesting to give you a live feedback. Residents of Grand Traverse County would have live web-based feedback on where snowplows were and where they've been. So you can actually track them and see where they're going and where they've been. I think he said that's going to roll out for next winter season. And then also, there's some more software coming called, I believe, Citizens Portal, I think, where people can go and provide commentary, Citizens Reporter on the Road Commission website, and you'll be able to, request basically work orders for the Road Commission, potholes or things that, need to be addressed, trees that are down across roads. Thought that was pretty interesting. We had a report from the Planning Department Talked a lot about some of the activity last year relative to units that were under construction. I don't remember if I wrote down the exact numbers, Claire, but in excess of 500 units are currently under construction in East Bay Township.
Yep, we've got about 800 residential units approved and about almost 500 hotel rooms that are
Okay.
under construction right now.
So a lot of activity in the township, as you're probably aware.
Oh, yeah.
Let's see, we also had a bit of a presentation from Grand Traverse County. They had two representatives here to talk about the ARPA funding. I'm sure you heard how some of that funding was divvied up, and I guess one of the bigger projects that they issued funding to was the East Bay Acme Sewer that runs. There's still some funding to fill in there, but this is going to be a considerable portion of it to help fund that sewer, parallel sewer along, I don't know, one of the roads behind 31. So big project that's needed, along with some other money that they're spending. I think East Bay Ambulance got some money for an echo unit. So basically another kind of standby unit that's equipped to act as a sort of an ambulance. So it was good. It was some good information, good reporting last night. There was a decision made to keep me on this board for this meeting. And
Thank you.
that's about it. Yeah.
I'll miss your accent.
Great.
And good comments, by the way.
Yes.
Yep. Also on the, are you done? I'm sorry.
No, I'm good.
Okay.
That's about it.
For the planning commission, we did a couple of things. One was that we approved the draft master plan after a lot of work, and that is now, I guess, going up before the township trustees, I presume.
Actually, Planning Commission approves it, so it's a
first.
done deal. Yep.
Okay, so that's good. Then secondly, we also approved a construction for the development of the Forest Hills 2 project. As you remember, we had granted them a variance, and that was what they needed in order to get approval. And so approval was given by the Planning Commission on that housing development. And then we passed our annual report up to the board for their review. We are also we also have the ordinance rewrite of which Lindsay is there. And we have just really started and cutting our teeth on some of the new ordinances. One is nonconformance, which we're putting a lot of more meat onto that particular section, as well as ZBA makeup in the process of another section we did. And then finally, an ordinance for the requesting rezoning, which is something that we needed to expand out and make clarification. And as a result of tonight, we know our work is ahead of us again, as far as the rewrite of the ordinance. And last but not least, I'd like to recognize that Trenton Lee is here, who is our alternate, who has been through us on these two meetings. Thank you, Trenton, for being here. Appreciate it. Okay. Public comment on that 7:28. 7:28. Oh, I'm sorry, 8:28. 8:28, thank you. Yeah, thank you. That's the second time you got me. 8:28?
Can I say something?
Yeah, public comment.
All right, Ethan Wilson. I'd just like to say thank you for hanging out here, going through, I don't know, thousands of pages. You've made a bunch of people happy over in East Bay Township, that right on the lake. And our condominium association has been there for over 40 years. And we've watched changes happen. We try to be good citizens and we don't complain, but you get to a point you have to. And so I thank you all for sitting here and going through all this paperwork and going through everything this evening. I thank you for your decision. I'm sure there's other people that aren't happy, but I just want to say thank you to staff and to all of you. Matt, good luck out there, though you're going to miss all these guys, I'm sure. So good luck with your trustee and everything else you have going on.
Thank you.
Preston,
All right.
do you need a sign-in sheet tonight, or?
We do.
Okay.
Yeah.
All right, we'll close the public comment at,
Sorry.
8:24. Upcoming meeting dates, February 14th, Valentine's Day.
And we are on. We do have one item on the agenda, possibly two for that day, but one so far.
Is it like tonight?
Not anywhere close.
Thank you.
Good. You might be able to celebrate Valentine's Day then. All right. That's it. Meeting is adjourned. Thank you.
Matt, thank you for all your time on here.